Hi, and welcome back. Attorney Steve Vondra, and welcome to another exciting episode of Trademark College. Okay, if you're joining me on a Saturday afternoon, I'm getting ready for the College World Series, but I thought that I would just go and put out this video on trademark damages. Okay, so this is a really important video. Sometimes you'll have a trademark infringement and you'll go, well, what are my damages? So without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, so I got it up here for you today. I've got my new Ring of Fire. If you might see that little glow right there, that's my little Ring of Fire. But at any rate, so we are talking about trademark damages. I'm going to go ahead and sit down here and pull out my handy pointer so that you can see this board a little bit better. Now, don't let this overwhelm you. This is just kind of how I break things down. So just follow along with my yardstick here, and we will go ahead and just cover these issues. So we're talking about trademark damages. This is general legal information only and not legal advice. The law may differ in your jurisdiction. I may have missed something. The law can change. So please don't rely on this without seeking counsel, okay? If you need more information, you can find out my website here at trademarkcollege.com. No, it's not a real college. It's just what I call my course here, okay? So at any rate, so let's talk about infringement. We know what a trademark is. It's like the Nike swoosh. It's the Shell oil sign. We know what the trademark is. It identifies the source of the products, okay? So, lots of companies, everybody has a logo trademark. There's slogan trademarks. There's sound trademarks, like the Intel sound. I think it's Intel doot, doot, doot. So there can be sound trademarks. So if somebody's infringing your mark, and here is our quick and dirty infringement overview. You have a registered trademark. That means you filed it with the trademark office. It's not too expensive to do. If you have no money, you're on a shoestring budget, check out my video, How to Trademark Without a Lawyer. We have a registered trademark. We have a nearly identical mark by the defendant, or we'll call that a likelihood of consumer confusion, something that's confusing people as to who the source is, the source of goods. One brand is luring in the other, that kind of thing. So you have a registered mark, nearly identical, likelihood of consumer confusion. And usually when you get into infringement, you want to look to see in your trademark application, did you have shoes listed in there? Did you specifically have shoes? And is shoes what's at issue? You would like the goods and services to be listed, goods or services, I should say, to be listed in your trademark application. And you always want to make sure you have priority. What does that mean? You want to make sure you're the senior user. You were the first one to use it, because somebody else, they may come before you, and you may have got your trademark and you think you now rule the country, but some prior use rights will likely exist for the other party. So you want to make sure these things are in check. If you have these and you go, I got the evidence, I got the screenshots, I see them, they're doing exactly what I'm doing, they're confusing and misleading consumers, then you may have a trademark infringement action. And then we come here into our trademark damages. That's what we're here talking about on a Saturday. So I drew my little pyramid here. This is money damages. Essentially, let's just take a look at it two ways. There's either actual damages plus potentially seeking attorney fees, or you can seek statutory damages. Let's talk first about the actual damages. I got my money sign there, money damages. Okay, so this is 15 U.S.C. 1117A, and what actual damages means is that the plaintiff is going to get their actual damages. Okay, so let's start right here. Actual damages. Defendants' profits can be a measure of those damages. We'll talk about that in a second. But lost customers, lost deals, lost viewership, loss of goodwill, all kinds of things can constitute plaintiff's actual damages. So you need to look closely at that and ask yourself, what can I prove? Okay, so think about your alleged infringement. What can you prove you lost? And when I say prove, I mean the burden of proof is a preponderance of the evidence. That means it's more likely than not that the infringement caused you damages. So that's your burden of proof. Again, loss in deals, so forth and so on. So that is really one of your measures of damages. Really kind of the hallmark of trademark damages is what's known as disgorgement, right here at the top of the pyramid. disgorgement of defendants' profits, ATF, don't forget this, that are attributable to the infringement. So they have to have profits that were attributable to the infringement. So if it's, they're just doing really well and great marketing, but it really had nothing to do with your logo or your slogan, your trademark, then they may be able to protect themselves as far as saying, sorry, there's other things that are not attributable. They're not going to get $1 million. Sorry. So you have here at the top of the pyramid, I put here no 2 times. That means no double damages. The courts do not want to award a double damage, and I believe that was the Nintendo case, if you want to look that up. But here's your general measure right here. Disgorgement of defendants' profits that are attributable to the infringement and plaintiff's actual damage that they can prove. Okay, so somewhere in there is your mix if you can show that. And I'm going to come down here in a second. If you're the prevailing party, in exceptional cases, make sure you highlight that. It's not going to be every case. Like copyright law, to me, is much better statute because you'll get your attorney fees, your reasonable attorney fees, if you can show that you'll prevail. But here in the trademark world, you need exceptional cases. What's that going to be? Something really bad, obvious, willful, malicious, reckless, oppressive, something counterfeit is another one. So you're going to get attorney fees, and usually, by the way, where you have attorney fee statutes, you, again, check in your jurisdiction. Usually that means a two-way. That means prevailing party could be the defendant, could be the plaintiff. Another incentive to be very careful and consult with your trademark lawyer before you're bringing these cases. You don't want to be on the hook for your attorney fees and their attorney fees. That can get expensive. Okay, so that's a possibility. I would say that's more of the rare case. You can seek your costs, your costs of filing, and some other costs that were incurred in the litigation. 2 final remedies: destruction. So if somebody sold 1,000 of your shoes, or has a whole, we have jewelry cases sometimes where it's, and let's just say jewelry infringement in the copyright world. And they'll say, well, you got, 200 more pieces. I want those either confiscated or destroyed, that kind of thing. So destruction of trademark infringing goods is another possibility. And the big one, this is probably the big one. I put it here on the bottom just because it has more letters, I guess. But, this is injunction. This is where you file your complaint. You go into court and say, Judge, this has to stop. Even if I can't prove any damages or they didn't make any money, I have a registered trademark. They're confusing my consumers, and I have priority, and I want to stop them. I want a court-ordered injunction, something I can serve on them and their attorneys to tell them to take it down, to stop using what you're using. So that's a big, powerful remedy. Now, you got to remember when you're going to get an injunction, there's going to be a test. You may be able to get a temporary restraining order, but then you have the preliminary injunction hearing. That's when the gloves come off and the dukes come out, and they're saying, I'm not infringing. This isn't going to confuse anyone. You're saying, yes, it is. Yes, it does. I've got evidence. So you want to get an injunction. To get injunction, you need to prove likelihood of success on the merits of the case, of your infringement case. So you need to convince the judge that this is an infringement and you're likely to succeed. And where that comes into play, you see what I have here, LLOCC, likelihood of consumer confusion. That's how I've always remembered it. Likelihood of consumer confusion. You're going to have to convince the judge that you have the grounds to succeed, that you can prove the factors. And I'm going to go over these real quick here. The likelihood of confusion factors. This is from the Ninth Circuit, the Sleekcraft case. Sleekcraft is the magic word. The 8 relevant factors, I'm not going to go into detail. I'm going to do another video on this, but briefly, the strength of the plaintiff's mark, how strong is it, how long has it been around, the similarity between the plaintiff's and defendant's marks, the proximity of the goods, any evidence of actual confusion that you have, the marketing channels that are used. So if you're both on the web doing podcasts on the web and it's the same viewers and same customers, that would be powerful evidence of confusion. The types of goods and the degree of care likely to be exercised by the purchasers. This is the sophisticated user. How sophisticated are they? Are they buying marshmallows or are they buying financial service products? 7, defendant's intent in selecting his mark. As you're going to see here, the intent is relevant because you need to prove willfulness if you want to get at these lost profits. So that's a very important factor that ties in. And finally, the likelihood of expansion of product lines. Somebody may be selling baby socks and they're going to sell baby gloves. So that may be a reasonable area of expansion. And if the defendant's encroaching into that area, confusing consumers, that can be a problem. So you need to show these to the judge. And so you need to be prepared up front when you file these complaints. I'm going to be able to establish these factors to the judges, to convince the judge that an injunction is warranted. They're not just going to give you an injunction because you're upset and you think you have a case and you hope to prove it. You need to come forward early on with an injunction. So there's your basic, what we call your actual damages, your money damages, the pyramid of love there. That's how you make some money in trademark cases. And as I put here, in these actual damage cases where you're seeking your actual damages, remember you can choose actual or statutory, but we'll talk about that. In these actual damage cases, the judge has the discretion to treble or triple the damages. So that's a discretionary measure to the judge. This is not something that's going to be a jury trial issue, but the judge has the ability to award 3 times. In the right case, this is 15 U.S.C. 1117B as in biscuit, prejudgment interest, actual costs and attorney fees, or statutory damages. So these are the different types. Now, these are your counterfeit cases, okay? So where you have counterfeit goods, I look at these a little bit different because you have better remedies. You have the potential for the triple remedy. You have prejudgment interest. That's nice. If you can prove your actual damages in a counterfeit case, you would seek your actual damages plus your attorney fees because you would argue you have an exceptional case here. And you could also, if you can't prove your damages, if you say, geez, I don't know what I lost or what they made, it's marginal, but I know they're using my counterfeit, they're using my trademark in a counterfeit fashion, you can seek statutory damages, which is anywhere from 1,000 up to 2 million per counterfeit mark type. So 1 to 2 million. So that can be hefty. In domain cases, 1,000 to 200,000. Remember, domain names are often using somebody's trademark. So again, you want to be careful when you're picking domain names and using domain names, okay? So here, if you get into a counterfeit case, you've got the willful. You can get at the defendant's profits. You can seek these beautiful different remedies. You have an election, as I put here. You have the election to choose the actual damages or the statutory damages. But remember, in the statutory damages, there was a case that came down in the Ninth Circuit, and it escapes me right now. But the case said, well, sorry, you can't seek attorney fees here. I know it's a little weird, follow me. But if you're seeking statutory damages, you cannot seek your attorney fees. So beware of that case. If you want to get your attorney fees, sometimes your attorney fees may be higher than this award. You would want to go elect the actual damages. So I know it's getting a little confusing here. Just stick with me. But I'm just showing you the different range of possible damages. Now, over here, coming to my little box here, I'm going to talk about the defendant's profits. This is a big question people have. Well, their profits, how does that work? Okay, well, again, if you need willfulness to show the profits, there's no jury trial for profits. It's going to go off the gross profits, the sales. So you look at a defendant, let's say they're selling software. You would say, okay, well, how many pieces of software pretending to be me did they sell? 1,000. So they sold 1,000, or you have a reasonable forecast of what their profits will be. You look at their receipts, their sales. If it's something online, downloads, ad revenues. Are they monetizing things? Are there revenues that they're making off of your back, trading off your name, basically hitching a ride on your trademark? And if so, add up those gross profits. That's going to be your baseline. However, under item B here, the defendant gets legitimate offsets. So if they have overhead, if they have operating costs, if they can show there was money made due to non-infringing factors, they can deduct that, okay? So the plaintiff proves this by a preponderance of the evidence, the defendant proves the offsets and the costs, and you get to this bottom line right here, kind of a total recovery. And then again, the judge has the discretion to add or, do what the judge needs to do on that. However, that discretion cannot start amounting to a penalty, because generally, unless a state law provides for punitive damages, generally there's not punitive damages in these types of cases. So it's that discretionary 3 times treble that we're talking about. And that comes from, if you're in the Ninth Circuit, the 56 Hope Road case. That's the 56 Hope Road case, talking about the judge having the discretion to increase profits but cannot make it punitive, okay? And finally, item D, no speculative damages. This is a hallmark in the law, is that speculative damages are usually not awardable. So if you say, well, I know it, I just know it, but you can't prove it, you're probably not going to recover it. So this is the area where you oftentimes get forensic accountants in there and experts and bean counters and people figuring out all different kinds of creative ways to argue damages, different ways to argue offsets. But as you can see, this can turn into, a pretty lengthy litigation trying to get all this figured out. But that's it. As I mentioned down here, when you get to these amounts where we're looking for the counterfeits, you have, up to $2 million per mark. So counterfeits is really your juicy case in the trademark area. Some of the factors that judges will look at when making these awards in the counterfeit area for statutory damages is the profits made by the defendants, the revenues lost by the plaintiff, the value of the mark. More famous marks are going to get more protection, and you also have dilution when you have a famous mark. We'll talk about that in another video. The deterrent effect, so there's always a concept of how can we deter this from happening again and send a message to the marketplace. Whether the conduct was innocent or willful, that's going to be a factor. Other things, the nature of the copyright, the circumstances surrounding the infringement, and a statutory policy of discouraging infringement. So those are some of the main factors that a federal court judge is going to look into. So there you have it. I know this ran on a little bit here, but if you have a trademark that's being infringed, this is going to be important stuff for you. Again, there might be some little details here and there. Check your local case law, check with your local counsel. But if you need help with a trademark case or more information, you can find us on the web at trademarkcollege.com. Now I got to get back to the College World Series, and Attorney Steve played in the College World Series, by the way, 1988 with the Fresno State Bulldogs. So I always enjoy watching the games in Nebraska, and you should too. So if you like this video, give me a thumbs up. If you don't like it, say, Attorney Steve, that's the worst I've ever saw. Tell me why. Or feel free to share this on your social media networks. And don't forget to subscribe. Thanks a lot. We appreciate you following us. We'll talk again. Bye now.